This is Unchained Frequency. I'm Malik Liberty. Welcome to episode 10 of License versus Liberty Part 3. Today, we examine three domains where the state commonly claims authority and, in the process, tries to convert liberty into license: marriage, work, and self-defense. We will show the constitutional boundaries, what the state may regulate, what it may not, and how the courts have protected it individual liberty across these areas. I will keep this strict, legal, and sourced. When I cite a case, I will give you the decisions so you can read it yourself at Law.Cornell.edu or Justia. No guesswork. If you challenge the facts I present, come with the case, not insult. Let's begin. Marriage, the Constitution, protections of choice and family. Marriage is a fundamental right. The Supreme Court has repeatedly recognized that the right to marry is one of the basic civil rights of man, fundamental to our concept of ordered liberty. The court does not permit states to make marriage a mere license the state may withhold as it pleases. The authority to marry stems from liberty, not license. Key cases and doctrinal facts. Readable citations. Loving versus Virginia, 1967. The court unanimously struck down state anti-Mexicanization laws and held that laws prohibiting marriage on the basis of race violate both the due process and equal protection clauses of the 14th Amendment. The decisions made clear that the right to marry is a fundamental right of individuals. See Loving versus Virginia, 388 U.S. 1, 1967. Justia law. Obergefell versus Hodges, 2015. The court held that same-sex couples have a constitutional right to marry, and that states must both license a marriage between two people of the same sex and recognize such marriages performed in other states. The opinion reaffirmed marriage's constitutional status as a fundamental liberty protected by the 14th Amendment. See Obergefell versus Hodges, 576 U.S. 644, 2015. Justia law. What these cases mean for license versus liberty: the state may set procedural requirements for marriage, e.g., age verifications, preventing fraud, enforcing health statutes, but it cannot use licensing to exclude groups from the fundamental liberty to marry or to make marriage effectively unavailable to certain people without strong constitutional justification. Loving and Obergefell make that principle plain. Justia law. Limited exceptions in prison contexts. The state's authority in certain contexts can be narrower. The Supreme Court in Turner versus Safley addressed marriage rights for inmates and established a test for prison regulations. The state's limitation on inmates may be upheld if they are reasonably related to legitimate penological interests. Turner is not a rejection of marriage as a right. It is a recognition that certain custodial contexts may justify carefully tailored restrictions. See Turner versus Safley, 482 U.S. 78, 1987, Justia law. Practical takeaways for my listeners. If a state or agency denies or conditions marriage in a way that discriminates against a protected class, or is not narrowly tailored to a compelling interest, you have constitutional grounds to challenge it. You must cite Loving and Obergefell. They are the controlling precedents. And you can read that at Justia law. Work, occupational regulations, the liberty to earn a living, and where courts give states leeway. The right to work and to pursue an occupation is central to individual autonomy and dignity. But the courts treat economic regulations differently from core personal liberties. We must carefully map where liberty ends and legitimate state regulations begin. Two broad principles. One, states have broad police power, authority to regulate economic activity, licensing schemes, professional regulations, safety standards, and courts often apply rational basis review to such economic legislations. See Williamson versus Lee Optical, CO, for the modern approach to economic regulations. Two, but when a licensing regime effectively burdens a fundamental right or is arbitrary, vague, or revokes essential interest without due process, constitutional rules bite. For example, when licenses is used to suppress constitutionally protected conduct or to target a protected class, higher scrutiny may apply. Controlling cases and doctrine. Williamson versus Lee Optical, 1955. The court famously adopted a differential standard for economic regulations. States need not have perfect legislations. Legislative solutions that are not entirely logical will survive so long as a conceivable, rational basis exists for the law. This case demonstrates the general judicial reluctance to overturn state occupational licenses on equal protection or due process grounds when only economic regulation is at issue. See Williamson versus Lee Optical of Oklahoma, Inc., 348 U.S. 483, 1955. Bell versus Burson, 1971. When a license becomes an indispensable means of livelihood or an essential interest, due process protections apply before the state may strip that license. In Bell, the court recognized that license suspensions affecting important interests require procedural protections. This case is often cited when license deprivations effectively deprive someone of a critical right or property interest. See Bell versus Burson, 402 U.S. 535, 1971, Justia. Key practical lessons. Occupational licenses is presumptively valid, but it is not absolute. If the license system, A, targets protected classes, B, is vague or arbitrary, C, lacks due process protection for removal, suspensions, or D, effectively blocks access to essential economic life without narrowly tailored justification, it can be challenged. Use Williamson's to understand the difficulty, and Bell and other procedural cases to identify procedural due process protection. How this ties to, quote, right to travel. When licenses is used to regulate commercial travel for hire, vehicles, interstate trucking, passenger services, states have broad power under their police powers and the Commerce Clause frameworks to require licenses. But private, non-commercial travel, an individual getting from A to B to visit family or worship is a fundamental liberty. Licensing regimes cannot be structured to penalize or deter private interstate movement or treat new residents unequally. See the travel cases, Shapiro, Science, Crandall, Justia Law. Self-defense, the right to keep and bear arms for lawful self-defense. And the Second Amendment is very, very important, everyone. Always remember that. Self-defense is a bedrock concern for liberty. The Supreme Court has recognized that the Second Amendment protects an individual's right to possess firearms for lawful purposes, including self-defense in the home, but the court also requires that modern regulations be consistent with the nation's historical tradition of firearm regulations. Foundational cases in the current doctrinal test: District of Columbia versus Heller, 2008. The court held that the Second Amendment protects an individual right to possess firearms for lawful purposes, such as self-defense in the home, striking down Washington, D.C.'s handgun ban as unconstitutional. See District of Columbia versus Heller, 554 U.S. 570, 2008. You can read that at Justia Law. McDonald versus City of Chicago, 2010. The court incorporated the Second Amendment against the states via the 14th Amendment, meaning state and local firearms regulations are subject to the Constitution. See McDonald versus City of Chicago, 561 U.S. 742, 2010. Text and analysis available at Cornell and Justia. New York State Rifle and Pistol Associations versus Bruen, 2022. The Supreme Court replaced the two-step interest balancing test used by many lower courts with a history and tradition approach. To justify a firearms restriction, the government showed that the modern regulations is consistent with the nation's historical traditions of firearm regulations. This is the controlling framework for post-Bruen challenges to state or local firearms rules. See Bruen, 597 U.S. 2022, Justia Law. The Bruen framework in practice. Courts now ask, is the modern regulatory scheme consistent with the historical tradition of firearm regulations? That's an interesting question. If not, it may be unconstitutional under the Second and 14th Amendments. Bruen shifted analysis away from the older means and balancing and towards textualist historical inquiry. Justia Law. Balance with public safety, what the state may do. Now, this is very important. The state retains power to enforce regulations that are deeply rooted in historical practice. Bans on dangerous, unusual weapons, licenses of certain commercial uses, but modern blanket bans or overly broad prohibitions face increased constitutional scrutiny under Bruen and Heller. Lower courts continue to apply Bruen, and as recently as 2025, circuit courts have both struck down and upheld various regulations. The jurisprudence is active, evolving, and fact-intensive. See current appellate decisions for up-to-date outcomes. You can read that at Reuters.com. Practical takeaways that you must pay attention to for all my listeners. The constitutional right to self-defense in the home is firmly recognized by Heller and McDonald. Bruen requires governments to justify modern restrictions by historical analogs. If a state imposes licenses or bans that cannot be tied to historical regulations, those laws are vulnerable under Bruen. Justia Law. Public versus private. What constitutional limits apply? A central legal boundary is whether the action is private or public. The Constitution constrains state actions. Not every private interaction triggers constitutional rights, but when private conduct is effectively backed, enforced, or entangled with the state, constitutional limitations apply. Key state actions, doctrine cases. Shelley versus Kraemer, 1948. Private, racially restrictive covenants were private contracts, but Judicial enforcement of those covenants was state action and therefore unconstitutional. The lesson is crisp. Private agreements become constitutionally suspect when the state enforces them. See Shelley versus Kraemer, 334, U.S. 1, 1948. Burton versus Williamson, Parking Authority, 1961. When the government and private enterprise are so entwined that the private discrimination is fairly attributable to the state, constitutional limits apply. See Burton versus Williamson. See Burton versus Wilmington, Parking Authority, 365, U.S. 715, 1961. Lugar versus Edmondson Oil Company, 1982, and Jackson's versus Metropolitan Edison Company, 1974. These cases refine the analysis. Mere regulations or heavy state involvement does not automatically create state actions. Courts examine the factual nexus or whether private action is fairly attributable to the state. See Lugar and Jackson summaries at Cornell and Justia. Practical rules. If a private party acts alone, a private homeowner evicts a guest without court involvement, constitutional claims are often not the right tool. But if the state enforces, authorizes, funds, or compels private contact, or court enforces a private covenant, state action exists and constitutional protection apply. Use Shelley and Lugar to make that argument in court. The 9th and the 10th Amendments is one of my favorites of the Constitution, well, all of them. 9th Amendment states that the listings of certain rights in the Constitution does not deny other rights retained by the people. Courts treat the 9th primarily as a rule of construction that the Constitution enumerated rights are not exhaustive. Use the 9th to remind judges that rights beyond the text exist and deserve respect. See Law.Cornell, 9th Amendment Overview. The 10th Amendment reserves powers not delegated to the federal government, to the states, or the people. It is a federalism principle that helps define the boundaries of federal and state authority, but does not authorize states to infringe constitutional liberties guaranteed by the 14th Amendment. See Law.Cornell for the historical and doctrinal background. The 9th supports the concept of unenumerated fundamental rights like travel and family autonomy. The 10th reminds courts that federal power is limited and that states should not assume authority to strip constitutional liberties. Both are useful in framing arguments, but controlling analysis would usually center on the 14th Amendment and Pacific Supreme Court precedents. Common misconceptions and rebuttals. Misconception 1. You need a driver's license to travel. Rebuttal. A driver's license is a license to operate a motor vehicle on public roads under statutory regulations. The constitutional right to travel is not the same as a regulatory scheme for a mode of travel. The key legal fight is preventing licensing regimes from being used to suppress the underlying liberty of movement. See travel cases, Crandall, Shapiro and Science, Justia Law. Misconception number 2. If the state issues it, it can take it away. Rebuttal. States can regulate, but they cannot constitutionally revoke fundamental rights without due process and appropriate scrutiny. When a license is effectively conditions of exercising a right, the licensing process itself must follow constitutional protections. See Bell versus Burson on procedural due process, Justia law. Misconception number 3. Private actors are free to do whatever. The Constitution doesn't apply. Rebuttal. The Constitution limits state action, and courts will find state actions when the government enforces, funds, or is entangled with private conduct. Shelley, Burton, Lugar. How to challenge invalid licenses. 1. Gather the record. Date, time, which agency, which statute code sections, names, badge numbers, written communications, citations, transcripts, photos, recording. Follow your state's recording law. Preserve everything. And always remember you do have a right to record. Number 2, identify the legal theory to plead. Constitutional claims under Section 1983 for deprivation of rights under color of law if a government official is the actor. You can also use Title 18241 and Title 18242. You can look those up. Equal protection or due process challenge if the licensing regime discriminates or lacks procedural safeguards. State action claim if a private party action is enforced by the state. Use Shelley, Lugar. Administrative exhaustion. If an agency requires you exhaust remedies, comply, but preserve constitutional claims for judicial review. File timely administrative appeals and create a paper trail. Seek emergency relief when necessary. If a liberty interest is being immediately denied, like child removal, essential license suspension, seek a TRO or preliminary injunction explaining likelihood of success on the merits and risk of irreparable harm. Cite precedents showing fundamental rights are at stake. Shapiro, Science for Travel, Loving, Obergefell for marriage, Heller, Bruen for self-defense, Justia law. Frame the pleadings. Use precise citations. Include controlling Supreme Court cases and the state action doctrine. For licensing challenges, emphasize either A, the regulation is not rationally related to a legitimate state interest, or B, a law burdens a fundamental right and fails strict scrutiny. Remember, Williamson is an obstacle for economic claims, so craft arguments to show the regulations actually burdens more than mere commerce. Use procedural safeguards. Demand judicial review, due process hearing, discovery where necessary, and attach affidavits showing how the license deprivation affects liberty interests. Partner with civil rights organizations when the issue affects broad classes. They can provide resources or amicus support. Recent cases in current climate. What to watch? Post Bruen, litigation continues to reshape Second Amendment law. Both circuit courts and district courts are actively deciding what historical analogs allow or forbid. Read Bruen and then consult recent appellate rulings in your circuit for updated standards. See Bruen summary at Justia or Cornell. Excuse me. Licensing regulations. Litigation remains active in state and federal courts. Where states attempt durational residency or discriminatory rules, Shapiro in Science remains the controlling authority for travel and residency equal treatment claims, Justia law. Recent federal appeals, 2025, have revisited machine gun and age-based restriction using Bruen and Heller as background. The legal landscape for weapons regulations is highly fact-driven and evolving. Follow Reuter's, Scotus blog, and circuit opinions. If you disagree with the facts and authorities I present, bring the case law. Don't bring insult. I will reply to reasoned legal debates, or I may not reply. Not personal attacks. I will not tolerate ignorance presented as facts, arrogance presented as argument, or bad faith attempts to mislead my audience. This show is built on primary sources, the Constitution and Supreme Court opinions. If you post attacks in the comments that are personal or that deliberately misrepresent the law, I will not engage, and moderators will remove those comments. If you keep it respectful and bring authority, I'll read and answer with the same. For everyone, read the cases I cite, verify for yourself. The law is the law, and primary sources are available online at Cornell and Justia. No hearsay. If you want to challenge me, do it with cases and citations. That is the only language this show recognizes. I'm Malik Liberty. No fluff, no fear, just straight facts.